Welcome back. Well, yes, Mr. Phillip Okey-Igwe joins us next. He's a legal practitioner to get his perspective on the same Taraba Election Tribunal judgment. Thank you for coming on this morning.
Thank you very much, Assembly.
Well, have a listen to Chief Michael Zekoma, SA, and many who think, well, the Electoral Act doesn't support that judgment, as he also said. But many also think that some others think, look, does it then mean that the PDP will benefit from their own wrong if they were to give them a second chance by asking that the elections be conducted afresh with them participating? Or will they go and hold fresh primaries to then validly, if they rely on this judgment, nominate their candidates to then participate? What's your interpretation?
My take is that, first of all, I listened to the senior advocate. I can understand why he was passionate about the way, what happened. Because if you look at this strictly from the letter of the law, if you look at the Electoral Act, Section 140, if the single issue is qualification, then what you're required to do, or what the tribunal is required to do, is to nullify the election. Because the Section 140 is the nullification provision of the Electoral Act. And then under Subpart 1, if you find that the candidate who had been declared winner of the election was not qualified to contest the election, then you are required then to nullify the election and order a fresh election. But you have to go back to history of the facts at play here and understand why we're here in the first place. Because everything in life, it seems to me, answers to principles. If you look at democracy, which we claim to be practicing, if you had gone to elementary school, you will understand that the definition of democracy is a government of the people, by the people, and for the people. And so the reason we're here in the first place is because the PDP, for whatever reason, violated this principle. What it means is that if you're going to practice democracy, power has to emanate from the people, right? And so if you look at the Electoral Act, this principle of government by the people is enshrined in Section 78. 78B, parts 1 and 2, requires that to contest a governorship in election, a political party has to nominate a candidate. How do you nominate a candidate? You go to every local government area. You let the people pick who their candidate would be, and then you submit the name to INEC or whatever the umpire, whoever the umpire is. So once the PDP violated this principle, then you have problems. And once you have problems in law, sometimes a court is allowed to engage in judicial activism, and that's what has happened here. It is not an unknown principle in law. If you look at history of jurisprudence, for instance, in America, to outlaw slavery, courts had to come in and engage in some kind of judicial activism. And so that's why when I look at this ruling, I'm looking at it from what happened in the Amaechi case, which is a seminal case, which is also a case where the courts are engaged in some kind of judicial activism. Once you violate the principle of democracy, then you create the room for what the court is doing here. And that's exactly what has happened. Like I said, and just give me a second and I'll round up my point. I understand what the senior advocate is saying. If you look at it strictly from a qualification specifics, then you have to nullify the election. But because you have violated the principle ab initio, then you created this room for what has happened here. Like I said, the judicial activism. It is not unknown to law.
It's interesting that you cite the Amaechi case, which is where a lot of people who have problems with this particular tribunal judgment also cite. They say if that is the case, I mean, because if the case is that the party was the one that won the elections, why would the emphasis then be so much on the candidate? Couldn't be a situation where perhaps fresh primaries will be reordered, for instance. After all, it is not in dispute here that the PDP did win the elections in Taraba State.
Well, you see, that's another area where I tend to disagree with the senior advocate, because the issue before the court was not strictly qualification. The issue was whether PDP as a political party was validly, whether they validly nominated the candidate and whether they, as a political party, because you have to understand, it's good that you bring up the Amaechi case. One of the dicta that came out of the Amaechi case is that it is not the candidate or a person that is elected into an office. It is a political party. So if that is the case, the issue before the court was not qualification. And in that case, you could say that the ruling was correct, because the issue now was whether PDP as a political party, which is now law from the Amaechi case, duly, or validly participated in the 2015 governorship election in Taraba State. And because, like I mentioned before, they violated the first principles of democracy, and it's coming back to, their chicken has come back to, come home to roost for them. So if you look at it from the Amaechi angle, I am going to make a, you can call me crazy if you like. I think what the court should have done, because the issue was whether the political party duly participated in election, I know for a fact that there was actually a primary in Taraba State where the then sitting governor, because you have to, if you go back to the history of this case, there was a sitting governor who got involved, who was involved in some kind of air crash, and then the deputy who was just nominated, I think it was 2 weeks after the car crash, became the governor. And then there were a lot of people who didn't like him in the state. A lot of the heavy hitters in the state didn't seem to like him. There was a primary in that state. And this is what led to the Abuja incident. There was a primary. My fact is not, I stand to be corrected, but my recollection is that he seemed to have won that primaries. But because a lot of people didn't like him, they now moved over to Abuja and conducted what you can refer to as a kangaroo primary that brought up this guy, Darius Ishaku. So if you go back to Section 78, which requires you to conduct primaries in every local government, PDP seemed to have done that with the then sitting governor, but they decided they didn't like the guy and then went over to Abuja. And so that's how we got to where we are.
There's this part, I haven't read the judgment though. Yes. There's this part which also popped up making the rounds, that not necessarily that they didn't conduct the primaries in Taraba, but yes, it wasn't within the stipulated time. Yes. As given by INEC. If that were the case, would it then be valid that, yes, if you held it in Taraba or Abuja, may be material, but if it's not within the stipulated time, it's another matter entirely?
Yeah, I mean, those are two different things. Whether it was held within the stipulated time is one thing. Another thing is whether, whether and if it should have been held in Taraba State. I am of the view that you have to hold it in Taraba State because that's where the residents of Taraba live. I mean, I don't know how you take out the delegates that should have been, participated in that election to Abuja in the first instance. Now, if the issue is whether it was held within time, I am making the case that the guy who was the then sitting governor was, they conducted a primary, which I think, I stand to be corrected, was held within the time allowed. And so, if you bring in the Amaechi case, if I was sitting in this, on this panel, what I should have done is nullify this election, order fresh elections, and go back to PDP and say, there was a governor, or your then sitting governor, who was part of the primaries, and he seemed to have won it within time. So we let him run.
So in other words, what the senior advocate Okey-Igwe did say, for instance, is that going forward, yes, what he had expected was for the tribunal to say, to order a fresh election. If they had gone ahead to order a fresh election, yes, on the basis of faulty party primary, yes, with the governor had been qualified, would we be seeing the governor as qualified to partake in that particular rerun?
Well, he shouldn't, because the whole point is that he was not qualified to contest. And you have to understand there are four prongs.
I'm looking at the political party, yes, as the one at fault here. If we are looking at the party as the one bringing up the candidate and not the individual Governor Ishaku, so would he also be a part of a fresh election if they had gone into a fresh election?